Okay, can we hear anything? That's gonna be the big thing. Can we hear anything? That's gonna be there it is.
Yes, we can.
Awesome. And now I
Okay, I'm good.
All right, this is Chuck Horton from the AG's office. Thanks to everybody for participating today. I don't know if everyone was on earlier, but just because we're doing this over the phone, it's going to be extra important that you identify yourself before you speak, so that the court reporter can accurately keep track of who's talking when. And I guess it probably makes sense for us to go ahead and do a roll call. We'll start with board members who are on the phone, and then we can kind of pick through who else is present. I'm just not certain, do we need to do everybody who's here all at once, or does it make sense to just kind of have people identify themselves as they speak?
If I could just get like the board members that are here ahead of time, and then identify as they speak, that would work perfect.
Okay, great. So, all right, John, go ahead.
Yeah, John Singletary.
Sylvan Oren. Karen Utterback Norman.
Forrest Luke.
Matt Wareham.
That's probably it.
All right, and John, I think you're chair this month, so I'll just turn it over to you.
So, I guess what I'm hearing is we have 6 members present. Is that correct?
We have 5.
Karen, Jill, Forrest. Oh, myself and Mel.
Yep.
And Tim isn't there, I guess.
That's correct. Yep, and Lauren's out today too.
Well, who's out today?
Lauren and Tim.
Okay. Yeah, well, this is John Singletary, and I'm calling the October 23rd, 2019 meeting of the Mine Reclamation Board to order. And with that, I would seek approval of the September 2019 summary of the minutes.
So moved, Karen.
Is there a second?
Jill second.
All those in favor signify by saying aye. Aye.
Aye.
All those opposed, same sign. Hearing none, the minutes are accepted. Approval of continuances and withdrawals. And have there been any changes on that?
There has been Cotter, actually.
I mean,
Oh, you mean on the, oh yeah. No. Sorry, I thought I meant the agenda.
Is there a motion to accept the continuances and withdrawals as shown? This is for it. Okay. Is there a second?
No second.
Okay. All those in favor signify by saying aye.
Aye.
Aye. Those opposed, same sign. Okay. That is accepted. Then we would, I guess we don't have anybody from the executive director's office for a report, but we have I think we have a division director report, possibly.
Yeah, John, this is Ginny. I do have an executive director's report that Tim emailed to me this morning. So if it's acceptable to the board, I'll go ahead and read it.
Great.
Okay. Tim apologizes for missing the meeting. He is signing the shared stewardship memorandum of understanding between the governor and USDA Undersecretary for Natural Resources and Environment, Jim Hubbard. And the purpose of that MOU is to establish a strategy framework to allow forest land partners to work collaboratively to accomplish mutual goals, further common interests, and effectively respond to the increasing suite of challenges facing the communities, landscapes, natural resources, and cultural resources of the state. And once it's signed, he'll share that with us. The executive director's office is currently interviewing for a legislative liaison and policy advisor. They expect to hire those positions soon. So as you know, Doug Vilsack was promoted from legislative liaison to assistant director for Parks and Wildlife. And then Julie left assistant director for energy and minerals to go to Oil and Gas Conservation Commission to serve as Jeff Robbins' chief of staff. And that left the assistant director for energy and minerals position vacant. But the executive director's office has decided they don't need an assistant director for energy and minerals at this point. And so they are hiring instead sort of a more of a policy general position in that spot. Oh, and actually, that's not true. They're hiring a climate position in that spot, which is taking over Taryn's role, who used to be with CWCB. But then in addition to that, they're hiring the policy advisor, which is what Amy Moyer used to do before she was promoted to assistant director for water.
All right, say that 5 times fast.
Okay, I'm going to go on now. I'm reading. All right, the Colorado Outdoor Recreation and Economy Corps Act is slated for a vote on the floor of the U.S. House of Representatives the week of October 28th. For those of you that are following that, this public lands package combines several popular proposals into a single bill that will protect wild places across the state, including the Continental Divide and Camp Hale in the White River National Forest, the most visited national forest in the United States, new wilderness and special management areas, as well as the country's first national historic landscape, and that will preserve history, wildlife, clean water, and booming outdoor recreation economy in the area. Also, the iconic mountains in the San Juan and Uncompahgre National Forests of southwestern Colorado by expanding popular wilderness areas and including lands that were left out of initial wilderness designations. Also, the Thompson Divide in the White River National Forest by ensuring that no future oil and gas or mining development occurs in the rugged wildlands. This will protect historic ranching and agriculture, outdoor recreation opportunities, and the state's largest intact aspen grove in along Kedler Pass. And then finally, I'm not sure if I'm pronouncing this right, the Curacanti National Recreation Area, which will be formally established by Congress as a unit of the national park system and includes an abundance of outdoor recreation opportunities, including boating, hiking, and fishing. And from Colorado Parks and Wildlife, later this month, the U.S. Fish and Wildlife Service will be releasing a draft recovery plan for the Gunnison sage grouse, a species found in Colorado and Utah that is currently protected as threatened. Throughout this process, they report to have been working with local stakeholders, working in the species habitat in Colorado, and involving county commissioners and other stakeholders. And then finally, in the Northeast region, territorial biologists took a tour of the U.S. Forest Service's National Black-Footed Ferret Conservation Center in Wellington, Colorado on Wednesday, the 16th. And CBW is one of 50 partner agencies working on restoring the species that were twice thought to be extinct. Colorado is home to 6 reintroduction sites. Regional biologists will be releasing new ferrets into the Soapstone Prairie area soon. And then finally, state land board commissioners approved a lease with Next Era Energy for 11 wind turbines generating 30 megawatts of power on 4 land board parcels in Kit Carson County as part of the 300 megawatt Bronco Plains wind project. And that project is expected to come online in mid-2020. And then lastly, not forgetting our avalanche center, remote avalanche control systems, a new system on Monarch Pass is done, but not test fired. Foundations for new installations on Wolf Creek Pass are complete. Sites selected with contractor are working on installation on Loveland Pass, and they're on track to have 3 new installations for this winter. So that's avalanche control systems I'm talking about, sort of remote sensing to anticipate avalanches in case, well, any season, but certainly if we have anything like last winter. So that is the executive director's report.
Any questions or comments regarding the director's report? Okay, Jenny, thank you so much. Yeah, I'm glad we got that personnel rundown, you know?
Yeah, hey, you bet. Board Member Singleton, I do have a brief division director report, if I may.
Oh, sure, I'm sorry.
That's okay. I just wanted to let everybody know that a few of us hit the road last week. Cammie, Russ, Travis Marshall with our Grand Junction field office, who's now senior there, and myself, and who am I missing? Okay. We went and visited the Grand Junction field office and had a nice employee appreciation time with them, following an employee appreciation day in Denver. Then we went to Narita and we visited with the Small Miners Association. And we talked about a number of things, but primarily what's going on with temporary cessation. That's a uranium country, and there's a lot of folks over there that are very interested in what's going on with temporary cessation in light of the recent Court of Appeals decision. And so we're going to be figuring out, what does production mean, and sort of following in line with that decision, and coming to the board with a proposed rulemaking that will follow a stakeholder outreach process. And that was really our first step in stakeholder outreach, although it's not our only meeting with the Small Miners Association. We'll be meeting with them again. But it was a very productive meeting. Senator Corn was there, and colorful and fun as always. And so we had a wonderful time. It was just great to get in that beautiful canyon country. That's all I have for the division director.
Okay, thank you. Moving on then, Chuck, we'll take the consent agenda. Did we swear all those people are going to testify at once on regarding our items today?
John, this is Chuck. Are you talking about the folks here who might have responses on the consent agenda?
Right.
Yeah, I think that's fine.
We have, everybody's here. So.
Yeah, they were all,
Okay.
I'll make sure that
Did you, if my staff, would you swear them?
yeah.
That's right.
I'm late caller. I wanted to announce myself. I'm sorry I'm late.
Okay. Well, please announce yourself.
Okay, this is Pete. Sorry, I didn't know if I was being heard. My name is Pete Brown. I'm with Earthworks, and I decided to call in and listen.
How do you spell your name, Pete?
Last name is spelled Bronkaers, and the affiliation is with Earthworks.
Okay. Do you wish to comment on anything? We're having public. We can have public comment right now. If you want to comment.
Not at this time. Thank you.
Okay. But before we adjourn, then, if you want to speak, speak up. All right. Chuck, could you go ahead and do the swearing in if we need what we need?
Yeah. So everybody who might give testimony, you swear to tell the truth. Yes. All right, John, you're good to go.
Okay. On item 4, consent agenda, the first item under that is Phillips County and Black Hills is our representative on that. Please have me do that.
It's just consent.
John, these are just consent items. So unless the board had specific questions about any of these, and the folks are here prepared to answer any specific questions, there's typically not.
Okay. Yeah, I understand that. I just noticed we have 5 minutes allocated, so I thought maybe if there's any comment from any of the board members or the staff, that'd be fine. If that's okay, Chuck.
Yeah, John, that's fine. I think that's why why the agenda has got time allotted.
Is there any questions or comments from the board, or is there anyone from the staff regarding any of these 3 items?
Usually there's 4.
Was there an additional part of that agenda, consent agenda? Was there an add-on?
Yes, John, it was the TC.
Which was
Item. Oh, I'm sorry. That's item D.
Item D. Oh,
No,
okay.
D,
All right.
as in dog. Yep, and that was the TC that was down. I think it was number 6 originally.
It's the Joe Craig, sorry, this is Chuck. That's the Joe Craig S&K number 1 LLC.
So it's moved to the consent, so the board knows, and maybe they already knew that, Joe Craig has moved to a consent agenda item.
Yeah,
Is that
it's a
correct?
TC1, so it got moved to consent.
Okay, so when we approve, if it's okay to approve the consent agenda, that will include, your item number 6 on your agenda, Joe Craig. Are there any questions or comments by the board regarding any of these items? Hearing none, could I have a motion to accept the consent agenda?
This is Bill, I move to approve the consent agenda.
Is there a second?
This Forrest, second.
Thank you, Forrest. All those in favor of accepting the consent agenda, please signify by saying aye.
Aye.
And those opposed, same sign. Hearing none, the consent agenda is accepted, and we'll move on to enforcement hearing, item number 5 on your agenda. And that would be Amy's presentation. Yeah.
Hi, everyone. This is Amy Eldell, the Grand Junction Field Office, and I also have Travis here with me as well. We need to get sworn into this one individually too.
Yeah, Amy. John, do you want to just do that? They're on the phone too, so.
Yeah, you swear to tell the truth?
Yes.
Yes.
Okay.
Okay. And just to kind of give everyone a heads up, I did notice that I had a typo, so I resent out a PDF
Right.
before the meeting. Only changes are there's a couple of 32.5 and it should be 32 because it's our draft. So I apologize, I didn't catch it sooner. But so anyways, to get started, good morning, members of the board. This is a hearing for consideration of a possible violation, civil penalty, cease and desist order, corrective action, permit revocation, and for failure to submit the 2019 annual report map and fee with regards to the Eagle Mine, which is permit number M 2011-029, operated by Jubilee Ventures Inc. It is a gold mine in Moffett County, located on BLM land, and it's a 112 hard rock. So, as I stated, consideration of possible violation, civil penalty, cease and desist, corrective action, permit revocation. And the chronology is on August 16th, 2019, was the anniversary date for the permit, which their 2019 annual report map and fee was to be due. On August 28th, 2019, the division sent out the reason to believe a violation exists and notice of board hearing. On September 18th, 2019, the division received notification from USPS that RTB was marked as reclaimed and returned to the sender. Both of those 2 documents are in your board packet. And then we have today's hearing, which is October 23rd, 2019. The statutes that were violated in the description of them are pursuant to CRS 34-32-116 parent 3, which says on the anniversary date of the permit each year, the operator shall submit a report and map showing the extent of the current disturbances to the affected land, reclamation, accomplished to date and during the preceding year, new disturbances that are anticipated to incur during the upcoming year, and the reclamation that will be performed during that upcoming year. Additionally, parent 4 states that all operators shall submit, in addition to the plan, a map and a fee as specified in section 34-32-127 parent 2. Then pursuant to CRS 34-32-124 parent 2 parent A, if the board determines that there exists any violation of any provision of this article or of any notice, permit, regulation issued or promulgated under authority of this article, the board may issue a cease and desist order. There's CRS 34-32-124 parent 6 parent A. Upon a determination after a hearing that a violation of the permit provision has occurred, the board may suspend, modify, or revoke such permit. And then Lastly, pursuant to CRS 3432-124, parent 7, any person who violated any provision of any permit issued under this article shall be subject to the civil penalty of not less than $100 per day, no more than $1,000 per day, during which such violation occurs. Next page, so the required notifications regarding the permit revocation, USPS certified mailing was sent on August 16, 2019, and the operator was provided with more than 30 days notice prior to the hearing was required. Regarding the civil penalties, as previously stated, under the list of statutes violated at the hearing, under CRS 3432.5 or 32-124, parent 7, at the hearing, if the board determines that a violation of a provision of permit act or these rules has occurred, the board shall assess a civil penalty of not less than $100 per day, no more than $1,000 per day for each day during which such violation has occurred. In this case, there's 56 days of violation, which is from August 28th to today. Today's hearing, which gives you a civil penalty range of $5,600 to $56,000. The board may suspend a portion of the civil penalty to encourage timely compliance with the corrective actions as well as compliance with the Act's rules and regulations. The board may also suspend all or a portion of the civil penalty based on the permittee's effort to correct the violation or violations prior to the board hearing. And then in italicized is anything that you guys want to read into the record. It says that payment of the unsuspended civil penalty portion shall be due and payable within 30 days of the effective date of the board order, unless otherwise specified in the board order where corrective actions are not completed by the corrective action date specified in the board order. The suspended civil penalty shall be due and payable within 30 days of the board order deadline for completion of the corrective action. Failure to timely submit any due and unpaid civil penalties shall result in immediate submission of such penalties. So last we have the staff recommendations. As I said, anything that's in italicized, the board can just read straight into the record if they want to accept them. First, number one, the staff is asking for the board to issue a violation pursuant to CRS 3432-115, parent 3 and parent 4, for failure to submit the 2019 annual report map and C. Number two, issue a cease and desist from all mining related activities pursuant to CRS 3432-124, parent 2, parent A. Number three, assess a civil penalty of $100 a day for the 56 days the violation occurred, for a total civil penalty of $5,600. Number four, revoke permit number M 2011-029, pursuant to CRS 3432-124, parent 6, parent A. Number five, find the financial warranty of permit number M 2011 in the amount of $56,620, subject to forfeiture pursuant to CRS 3432-118, parent 1, parent B. And lastly, direct the staff to schedule a board hearing for forfeiture of financial warranty and provide proper notice of the hearing to the operator and the financial warrantor in accordance with the provisions of CRS 3432-118, parent 2. And that is it, unless you guys have questions.
Any questions from the board? And I noticed you mentioned, on the bond, questioning the bond, you said it looks like the bond's inadequate. Is that true? I mean, where are we sitting on that?
Yeah, so we're about $1,300 shy. The background is that this being a hard rock site, we go out there annually. And so with us having those updates to Cersei's, the cost, we're trying to catch up. What I've been trying to do is make a point of updating the bond every time we go out there to give them incremental changes. But this operator's MIA. So basically we issued the surety increase. That's technically out there, but we only need the annual fee to start moving forward with taking the permit because they're gone. So we're fairly close as we calculated last year.
Your math is different than mine. I see we have an existing bond of $53,000 and suggested $67,000. That's a $13,000.
13, sorry, yeah, 13,000, not 1,300.
Okay.
And it is a cash
All right,
bond.
All right. Any questions from the board members? And there's nobody representing the permitting or there to speak on their behalf, no representation.
That is correct.
Okay.
That was last week.
Any
Thank you.
With that, any discussion with the board? What's the pleasure of the board handling this matter? Is there a discussion or a motion, or what's your pleasure?
This is Jill. I had a question for Chuck. Is it possible that we move to adopt staff recommendations rather than rereading all of them on the phone?
Very nice. Chuck, what do you think?
It's been read into the record. The recommendations are part of the record. I think the record will be clear, and I should be able to draft a clear order reflecting that, Jill. So I don't have a problem with that, given that we're on the phone.
Well, that's nice of you. Okay.
Yeah, this is Jill. I will make a motion. I move that we adopt staff recommendations numbers 1 through 6 for permit number M 2011-029.
Is there a second? Four seconds. Okay. Any further discussion? If not, then all those in favor of the motion, please signify by saying aye.
Aye.
Those opposed, same sign. Hearing none, the motion passes. Okay.
Thanks, Amy.
So,
You know what
we
they,
really have left here is
no, they don't have Cotter.
I sent him a text.
They don't have Cotter on their agenda.
Oh, okay.
Oh,
John, this is Chuck. So the remaining item is Cotter's motion for continuance. Cotter's counsel is here, as is Robert Tuchman, as is Jeff Parsons, counsel for objectors. Mr. Tuchman is trying to get Ken Mashinsky from Cotter on the line. And I don't know if we want to just hold on for a second to see if we can get them to call in. So I guess just hang tight for a minute if that works for the board.
ready to win. Alert us when you're ready.
And just, everybody's got the documents, right? I know Cammie had sent those out, so.
Yep.
Thanks, Robert. Okay, great.
oh, right there. Hello? Did somebody new just join? I wonder if that was Amy departing.
Sounded like it.
It is trying to call in right now.
Okay, that's fine.
Hi, this is Jennifer. I know Lexi Cunningham from Sheep Mountain Alliance is also calling in and might be on.
Yes, not here.
And can we get a spelling on your name, please? Can we get a spelling on your name? The one that's with Jennifer? We got Jennifer Thurston. There was another one too.
Keith Strongford and Lexi Cunningham, which is, there you go.
ENHAM from Sheep Mountain Alliance.
And then there was one more.
Ken, are you on the line?
Yeah, this is Ken Mashinsky, Mushinski.
And you're with Cotter. Okay, thank you.
Are we clear?
This is Chuck. Yeah, I think we're all ready to go.
Ask Alyssa, are you good?
Yeah, I'm good.
Okay. Okay, sorry about that, guys.
You're better than I, but, Do we need to swear these people, Chuck?
Yeah, John, I think that's appropriate, although it's really a consideration of emotion. There may be some testimony from folks regarding the grounds for the motion, so might as well.
Okay. And all those who plan to talk and testify regarding this issue, do you swear to tell the truth? Yes.
Yes.
Yes, yes.
Okay, all right, then we'll proceed.
This is Jeff Fugate, attorney for the division. I'm just going to kind of set the table for this particular motion, and I'll hand it off to the parties to present arguments. The board should have received a copy of Cotter's motion for request for continuance of consideration of temporary cessation 2 for the 9 listed lines. I'm just going to kind of hit the high points, just frame for the board how we got to where we are. Back in 2017, Cotter submitted notices of the second period of temporary cessation related to mines out on the western slope. That matter was continued or stayed because of an injunction issued by or related to a federal lawsuit. These matters found their way back to the board in July of this year to consolidate in a kind of a standalone Cotter Mine JD8, consolidated in with the other pending matters, and then also to continue consideration until the board received an order in the van for litigation. And then the last item was to continue it until the injunction was lifted, I believe. Is that part of that? Maybe not. In any event, it seems that all the matters that have led to kind of the continuation of continuance have been resolved for the most part. The injunction has been lifted. We did receive an opinion from the Court of Appeals in the Van 4 matter, and now all of the Cotter mines have been consolidated into one, I guess, group of mines for consideration of temporary cessation 2. I did reach out to the parties by email in late September and offered up some hearing dates, trying to coordinate schedules and availability. There was some dispute regarding the available dates. And because of that, rather than trying to resolve that just through division and discussions, we decided to set this matter for hearing in November, which we have done. And Cotter has filed a request to continue consideration of these temporary cessation 2 matters. So that kind of sets the stage as to how we got to where we are. I'll hand it off to Robert Tugman, who is here in the room, to present his motion. Jeff Parsons is also here on behalf of commenting parties who will also likely testify and provide some information to the board.
Thank you, Jeff, and thank you, board members, for hearing this on a relatively expedited basis, Cotter's motion. As Jeff indicated, as Mr. Fugate indicated, Cotter has filed a motion asking the board to continue the hearing on Cotter's 10 notices of temporary cessation, continue the hearing from November 13 this year to February 2020. Just to fill in a few of the details that Mr. Fugate was referring to, and by way of brief background. So in late September of this year, Mr. Fugate sent an email to myself and to Mr. Parsons proposing hearing dates on Cotter's notices of temporary cessation. And those hearing dates were November 13, December 11, and January the 22nd. Cotter responded that those dates did not work for it, gave reasons, and proposed that the hearing go forward in February 2020. On October 10, Mr. Means sent a letter to Cotter setting the hearing for November the 13th, next month, but stating that Cotter could file a formal request to continue the hearing based on good cause. And so on October the 11th, Cotter filed its motion seeking a continuance. The subject matter of the hearing, the notices of temporary cessation, are indisputably important to Cotter. What we're talking about is obtaining a second 5-year period of temporary cessation for 10 uranium and vanadium mines in southwestern Colorado. The mines have enormous value and substantial rights are at stake in the hearing. To protect those rights, Cotter will be offering testimony on multiple fact-specific issues, including, without limitation, touching on the operating histories of the mines, the uranium and vanadium reserves that are remaining in the mines, Cotter's investments in the mines, including the preparation of the environmental protection plans, the adequacy of each mine's financial warranty, impacts of the federal injunction that prohibited exploration, drilling, and mining, the division's historical regulation of the mines, market conditions for uranium and vanadium, and ongoing lease negotiations between Cotter and the U.S. Department of Energy. Cotter's principal witness on those topics is Mr. Mushinsky, who's on the phone. He speaks for Cotter. He's Cotter's most knowledgeable person. No substitute exists for Mr. Mushinsky's testimony. It is therefore important that the board schedule the hearing on the notices of temporary cessation for a date when Mr. Mushinsky can attend the hearing and testify. His testimony is critical to the temporary cessation issues. His presence at the hearing is critical to assisting me, Cotter's counsel, and to present a robust summary of Cotter's case, as well as the evidence. The immediate problem that we have, and this was part of the email exchange back in September, the immediate problem is that Mr. Mushinsky is not available for this board's hearing in November because he will be in Western Asia on business. And he made those commitments long before the division selected November 13 as a hearing date. Mr. Mushinsky is also committed to related matters the week of December 9th, which knocks out this board's December 11 to 12 hearing. Holding the hearing on a date where Mr. Mushinsky cannot be present would severely prejudice Cotter. And the Colorado Supreme Court has repeatedly recognized the importance of scheduling judicial proceedings when a party can attend those proceedings, assist defense counsel, and thereby get a fair hearing. As stated in Cotter's motion, and again, this is from Gonzalez v. Harris, a Colorado Supreme Court case, a litigant has the right to be present to assist his counsel in the trial, and his necessary absence is a good reason for a continuance. So at the very least, what we're saying is we need to schedule this hearing for a date other than November and December. Now, good cause also exists to continue this hearing because this month, the U.S. Department of Energy first started the explanatory process for negotiating new leases for 9 of the 10 mines that are at issue in the proceeding. So we've got these 10 uranium and vanadium mines. 9 of them are on federal property. And for those 9 mines, Cotter has leases with the Department of Energy. There is a 180-day window for negotiating those leases. Cotter doesn't know how long it's going to take to come up with new leases, but it believes those negotiations can be completed by February next year, 2020. Finalizing the leases will be important to the temporary cessation hearing. The leases are important for issues of mine access, but the lease negotiations could also end up limiting the number of mines for which Cotter ends up pursuing temporary cessation. There are economic issues involved with the leases, and Based on negotiations, it may be that the number of mines for which Cotter executes leases could be something less than 10, which would mean that there would be less mines to consider in the hearing on Cotter's notices of temporary cessation. Important point is that Cotter had no control over the Department of Energy's decisions to start the explanatory process on the lease negotiations this month. Our understanding, the Department of Energy believed it could not start negotiating new leases until the injunction lifted, and the injunction lifted in March of this year. And wouldn't surprise anyone to know the government moved slowly, and they first started this process in October. Good cause also exists to continue the hearing because of the United States Nuclear Fuel Working Group that was initiated this year by the executive branch and will be issuing its report later this year. President Trump directed the working group to develop recommendations for reviving and expanding nuclear fuel production in the United States. That report will be directly relevant to the importance of resuming uranium production from the mines, and again, could also, depending upon what that report finds and the directives that the president issues pursuant to the report, it could also impact the number of mines for which Cotter pursues temporary cessation, and therefore could limit the hearing that we've got. Point of clarification on my part. In the motion, I stated that I had conflicts with hearing dates in December and January because of a federal court case in which I am involved. After filing the motion, the court vacated the dates, the scheduling dates that were creating the conflict for me. However, I need to impress that a new scheduling order will be forthcoming, and the new dates in that scheduling order very well would create a conflict for me for January. However, I just want to be clear that the judge did vacate the dates that were directly causing the conflict for me. One of the big issues that the Colorado appellate courts consider when they're looking at a motion for continuance is one of prejudice. And in the negotiations that I've had with Mr. Fugate and Mr. Parsons by email, no one has stated that they will be inconvenienced if this hearing were to be moved from November of this year until February of next year. Furthermore, no harm to the environment is going to result if there is any such movement. As explained in Cotter's motion, Cotter maintains the mines in accordance with the board's rules of the environmental protection plan, and it is Cotter's understanding, based on recent inspections, that the division is pleased with Cotter's maintenance of the mines. Furthermore, Cotter is asking the board to continue this hearing for 1 month past the 3 dates that the division proposed initially. So the division was proposing November, December, or January, said either of those times would work. We're just asking that we go 1 month later until February. Therefore, I fail to see how there would be any prejudice to anyone or the environment if the continuance were to be granted. Cotter understands the division's interest and the board's interest in avoiding the delay. Cotter did not cause this delay. The biggest delay factor was the injunction ordered by the federal court that prohibited mining for 8 years and was first dissolved on March 18, 2019. as explained by the Supreme Court, avoiding delay is not a basis to deny, delay is not a basis to deny a continuance. Legitimate concern for the prevention of delay in the trial of cases should not prejudice the substantial rights of parties by forcing them to go to trial without being able to fairly present their case. Here, if forced to go to a hearing in November 9, 2019, Cotter's substantial rights would be prejudiced. Cotter cannot fairly present its case without Mr. Mashinsky being there. No prejudice exists if the hearing is continued. We therefore respectfully submit that this board should issue an order continuing the hearing from November 13, 2019, this board's meeting date in February 2020. And Mr. Mashinsky, is there anything you'd like to add on that?
No, not much other than, the facts are correct. And I would suggest that, I was aware that, this matter would be coming before the board. And I have, I've reached out to the DOE very shortly after the March 18th lifting of the injunction saying, hey, when can we get started negotiating, these leases? Because the leases, in fact, in the DOE's opinion, have expired. And we're kind of in this gray area of we have leases or we don't have leases. In the DOE's opinion, the leases are expired. We're operating in this 180-day window to renegotiate leases that was told until the time that the injunction was listed. So during the injunction, the leases expired. The DOE told the starting of the 180-day renegotiation period until after the injunction was lifted. And very shortly after the injunction was lifted, I contacted David McNeil, who is I believe he's the head of the real estate for the DOE, and asked him, hey, when can we get started on this? And, I got several replies back saying, we're not ready yet. We're not ready yet. And it wasn't until the 1st of October that they were ready to just, start the process. So I feel that, and by all means, Cotter has done everything has been as proactive as we could to get this process going. And, to follow up on the 232, everybody's probably aware of the 232 complaint that a few uranium miners filed with the U.S. government that was out of that decision or out of that complaint came which was in July, August. It was recommended that a working group report back to the President of the United States on the status of uranium mining in the United States. That report was due October 10th, and it's been delayed another 30 days. And what comes out of that report, whether or not the government is going to want to stockpile uranium and other nuclear fuel cycle components, is material to whether potential decisions Cotter makes on uranium mining in Colorado. So that I think that's really all I have, and other than that, I am out of the country and unavailable in November and December as Mr. Tuckman stated. So that's all I have.
The other thing I'd like to point out is I've tried to read as many of the Colorado appellate decisions as I could dealing with granting of continuances. And, most of those cases are dealing with a situation where you've got, for example, a trial date which has been in effect for a long time, and then you've got some set of circumstances that arise relatively close to the trial date, which requires one of the parties to the trial to seek a continuance, such as a health problem. As laid out in the Gonzalez case, there was the plaintiff was detained in Mexico, or there could be a weather situation. Here I see it as a little bit different. And the reason it's different is because we're really in a position where we don't have this hearing date that has been set for a long time. It's more a situation where, as Mr. Fugate pointed out, the previous circumstances have been dealt with, namely the injunction got lifted, the Colorado Court of Appeals issued its decision in the Inform case, and now we're in a position to say, fine, let's set a hearing date. So my view of it is the parties can get together and collaboratively come up with a hearing date that works in everybody's schedule. That was the ultimate effort here, to come up with a hearing date that would work for everyone. And that's why we said November and December don't work, because Mr. Mushinsky can't be there. I had that specific conflict in January, still may have the conflict, but I can't say it's absolute anymore. And then given with the DOE leases and given with the uranium report coming out, it just seemed to make sense to agree to do this in February. I heard no objection from anyone that it was a problem for them to do it in February. And based upon what I was hearing about the status of the mines and their maintenance, this isn't a situation where there was going to be a contamination issue. So for all those reasons, it appears that that's why we're respectfully asking that we just schedule this hearing for February of next year.
Any questions from the board? And thank you, then, for your comments. I'd like to visit with the staff. Jeff, what are your thoughts?
I think maybe you should hear from Mr. Parsons first for response from the interested parties, and then I think we can give you a staff's perspective.
Okay.
Thank you, members of the board. Thank you, members of the board. This is Jeff Parsons. I represent Inform, Sheep Mountain Alliance, Earthworks, and San Juan Citizens Alliance. In this matter, they are the objectors. Obviously, these issues have been sort of swirling around for some time. I guess I'll start at the start. The rules detail the board's procedure in these matters. 1.13.61 discusses scheduling of the hearing, and it does reference placing the notice of temporary cessation on the agenda for the next regular board meeting once the temporary cessation submission has been made. And in our view, that submission was made upon resolution of the Inform case in the Colorado Court of Appeals. That was the predicate for the continuance that was issued previously. So I think the board's rules certainly support sort of an expedited, or at least a timely process in that regard. The board rules at 1.13.62D do reference continuance of the matter, but it says to allow for the operator to revise the notice of temporary cessation and or allow the office staff to conduct a site inspection or otherwise review the matter as necessary. Our position is that neither of those apply, and so under the rules, a straightforward reading would be that November would be the appropriate time to do that. I think it's important just to take a perspective here from the citizens out who use those lands, who recreate, hunt, camp, enjoy the wildlife, that this TC status for these mines expired in December of 2017. So here we are, a full 2 years past the date that these issues in a normal situation would have been resolved. And importantly, these are mines. I think it's important to keep in mind that these are mines that have had a full 3 terms of temporary cessation for the most part. There are a couple exceptions, but 3 full terms of temporary cessation, in addition to about 20 years of intermittent status, which, as I think the board has heard from staff, was probably not the appropriate, in fact, was not the appropriate status for them to have. So the objectors here are dealing with what appears to be just an endless delay in being able to present their arguments on this issue. Mr. Tuchman raises issues regarding the lease negotiations, doesn't know how long those will take. A nuclear fuel working group report, doesn't know how long that will take. Doesn't know if there'll be a trial in some other matter of his scheduled that might further. So it looks like further extensions are, a real possibility, and that of course raises those concerns and even more relief for us, because it appears that we'll be sort of at the whim of the DOE, which frankly, I agree with Mr. Tuchman, they are not speedy. I mean, they had an injunction issued in 2011 or 12, didn't get their EIS together until 2014 and couldn't get it past the court until 2019. So it took DOE 7 years to comply with federal law. So that's, not exactly something I want to hang my hat on in terms of making our hearing date contingent on DOE's ability to get their act together. I think it's, with respect to the witness testimony, I think it's critical to look at this recent Colorado Court of Appeals decision, because it clarifies that the only operative question is whether production has ceased for longer than 10 years. The court made very clear it doesn't matter what the regulatory history is or what the historical market or the operational history in terms of those are arguments that were made before the court and were rejected. And so many, if not all, and I would say all, based on my understanding of the issues that Mr. Tuchman has indicated would be the focus of testimony in this case are frankly irrelevant. There were extensive hearings in this case in 2012, and again in 2007 or 2018. So the record in this case is very well developed and includes admissions from Cotter and confirmation from the division as to the cessation of production at all mines for longer than 10 years. No amount of additional testimony or exhibits will change the facts on the ground, which are already established in the record. So our position is there's no need for any additional evidence to be taken or testimony to be made. The court was very clear, Court of Appeals was very clear that the thing that matters is, as a matter of fact, when did production cease and has it been longer than 10 years? And in the case, each one of these mines, the unequivocal record demonstrates that yes, it's been longer than 10 years. So the idea that we need a trial and we need the aid of a bunch of witnesses to conduct this hearing, I think is simply not true. Now, I understand that this board's practice is to give every party the benefit of the doubt and to be, accepting of representations that someone wants to present their side. And I get it. I think that's good practice. It's good government. And so maybe there's, my suggestion is there's potential middle ground in this case. For instance, Cotter has raised in its most recent filings with respect to JD8 at least, and my expectation is this is something that would be applicable again to all mines on their side, is of asking the board to review a request to toll the TC period. This was already rejected once by the board, but I assume or expect that that's a legal issue that would likely, among several possibly, that would likely be raised by Cotter again. And that's an issue that can be dealt with on the law. It's not an issue that requires witness testimony. It's a legal issue as to whether there is a basis for a tolling, or if there's any discretion by the board, which of course we would contend there isn't, to toll the TC period. Similarly, the objectors believe there are purely legal issues that can be addressed without testimony. And that was sort of the motion, or the issue that I just raised, that the Court of Appeals was very clear that the relevant factors in this case are really when production ceased. And we believe that the record is unambiguous and uncontroverted and very clear with respect to each of these mines, and does not require any additional testimony. And that can be raised as a matter, that can be resolved rather as a matter of law before the board in November. So what I'm suggesting is that the board could essentially bifurcate this hearing to allow these legal issues, allow any party to file a legal motion to be heard in the November hearing, the November board meeting, and have those legal issues presented, and the board can make any rulings it deems appropriate. If the board believes that additional testimony beyond the existing well-established record is necessary, it can schedule that portion for a future board meeting. And it appears that January is back on the table in terms of a prospective board date. And I would certainly encourage that schedule as opposed to February, because I really do think that time matters in this case, given how long we've waited. This would allow the board to address the threshold issues up front, and frankly would help make that future hearing, to the extent it's necessary, much more simple. I think the board might remember, some members might remember the last hearing we had on this, and it got complicated pretty quick. I mean, there are 10 mines now associated with this. So it seems to me that anything we can do in November to resolve what are threshold legal issues is worthwhile to engage in. As far as, I mean, I could address the harm to the environment. I mean, I understand the point that there's no evidence of an ongoing leak or a breach, but our position is that there is contamination out on that land. There's evidence in the record that there's uranium residue and radioactive material that's out. And we believe that poses a threat. It's obviously impacting wildlife habitat in the area, and it's impacting the public's ability to use and enjoy the land, including objectors and their members in this case. And so that would be my suggestion, is that this board allow the parties to present legal issues for to the extent you grant the extension at all, frankly. But if any, to allow the parties to present legal issues on motions for the November hearing, and then to the extent further evidence is necessary, schedule that for, at least have a presumptive schedule for January for that hearing to take place. Thank you. I really do appreciate being able to speak with you, even though on phone. Thank you.
This is,
Board members, any question of this person?
this is, oh, I'm sorry.
Any other questions? If not, Jeff, can you give us a summary of your direction and thoughts?
Sure, Jeff Fugate here again on behalf of the division. Just to circle back on kind of the origin of efforts to try to coordinate a hearing date. You know, the dates, November, December, January, were provided in an effort to try to reach some agreement as to when this matter could be set to allow sufficient time for potentially for a pre-hearing conference to get parties together to set the hearing schedule, time allotments, you know, number of witnesses, things related to just the hearing structure itself, and then also to allow sufficient time for briefing. Again, as Mr. Parsons outlined, there are some significant legal issues here, and so there will be, I would anticipate, substantial briefing in this matter. kind of the record on these cases, there has been significant briefing in the past. I would expect that to be the same. So that was really the division's purpose in sending out the dates, is to try to reach resolution. When it became clear to the division and myself that it was unlikely we were going to be able to kind of broker an agreement on the hearing date, we decided that was not the type of dispute that was properly resolved by division staff. That's why it was set for hearing, with the allowance for the parties to make whatever arguments they wanted for continuances, which Cotter has done. As far as the request for continuance, the division really has no position on whether it should be granted or denied. The division will be prepared for hearing whenever it is set, whether it's in November, January, which now may be available, or February. I believe any of the dates the parties can come up to speed. So division's just not taking a position on this matter. We're going to defer to the board on that.
This is Robert Tuckman. May I respond? Mr.
Yes,
Parsons,
but keep it short, please.
will do. Mr. Parsons referred initially to Rule 1.13.6. Nothing in the board's rules would limit the board from exercising its discretion to pick a hearing date that would set forth an orderly process for resolving these issues. Cotter is not requesting an endless delay of the hearing. It is saying pick a date. It's not saying when the DOE finishes the lease negotiations. Cotter believes the negotiations will be done by February. Cotter is saying let's do the hearing in February. Cotter is saying let's continue the hearing date. Let's terminate the November hearing date, and let's pick a new date, such as February. In terms
Okay,
of
that's fine, sir. The board knows this. We know we have that discretion. I appreciate it. But that's fine. I want to hear, are we finished with Jeff, are we finished with your thoughts?
Yes, I have nothing further to add.
I just don't want to continue to hear the same thing over and over again. I want to close the hearing, and we really don't even have a hearing on, but I want to hear comments from our board members. Any thoughts or ideas from the board?
This is for us, I guess, after hearing the testimony. I think sounds like there's legitimate reasons to post the hearing until January or February. I think both people that need to be present, as well as the lease information. I think they probably will know more by then. So I guess that would be my thoughts. What would be the harm in putting it off for a couple of months?
Okay, any other comments from board members?
Yeah, this is Jill. Go ahead. No, go ahead, Jill. I'll come in later. Okay. Thank you. I recognize where the objectors are coming from and understand their frustration with waiting, having to wait longer. I do not think it makes sense to clearly to bifurcate the hearings. I think the board does well. It's better when we have everything in front of us at one time, and we try to remember everything. And I know there's legal issues and factual issues, but I think it makes sense to take them all together and have everything, and have everyone that we may want to ask questions of there. And so I agree with Forrest. I understand the frustration that this has taken a long time, but I think moving it to February makes sense under these circumstances.
Thanks, Joe. Any other comments from board? Oh, Kate.
This is
Go
Karen.
ahead. Karen.
Does the board feel that maybe we need to say, all right, we'll move it to February, but at some point, this is gonna come to an end. It's always like, well, somebody else has set a meeting or a deadline before we've gotten to discuss it and set our deadline of when something has to happen. And I think, just to continue on, one would not like this to happen, but, it is a possible, occurrence. Do we need to set a deadline so that they can go forward to any other entity and say, look, this is set, this is the only time we can do this, and this, it takes priority over some other meeting or some other decision that has to be reached by some other agency down the road. I don't know, how does the board feel about that? We say it's February, and it's gonna be February, and that's it.
I think that's all we can do when, again, we're not privileged to what other organizations play into this thing, but I think if we set it for February, that's what it'll be. And, so anyway, any other comments from board members?
This is Mel. I would echo what Bill commented about, even if there are, direct legal actions that could be brought up earlier, having the whole conversation together really helps in context and helps us remember everything all pulled together. So not in a delaying sense at all, but for the sake of efficiency and greater understanding for the board. And also, to Karen's point, I think we do need to say, this is a priority, this is the time, this is the end date, so all parties are aware of that resolution.
Yeah, I agree. I also, we kind of see there's a turmoil obviously in the Department of Energy right now. It's probably won't, by the end of this week, probably won't have a director, which is not unusual. But also, probably one of the things Connor's concerned about is that this administration is putting a new focus on that kind of material for the nuclear possibilities. So I kind of would like, I want to hear that, and I agree with what you said. I want everybody to sit down. When we hear it, I want to hear everything they can. And I think to the people that are worried about it, I'm just as worried as they are. But I want to make the right decision. This is a big question in Western Colorado, and actually even where I live in Pueblo, east of Pueblo Canyon, the uranium is a big deal. So I think we take it very seriously, and I think we're going to be real thoughtful about it. We have in the past. But I don't really find, February as being offensive. We also want to be very fair, but I think there's going to be some new conversation during that period of time regarding, that kind of material. So I would support, a February meeting. But Karen, back to you. I'd like the people to know that we're serious about that date.
Ms. Forrest, again, I basically agree with everything that's been said.
You want to make a motion for us?
Sure, let me, I move that we grant the request by Cotter Corporation, file number JD9 mine permit number M-1977-306, JD6 mine permit number M-1977-310, Mineral Joe Claims permit number M-1977-284, SR11 mine permit number M-1977-451, SM18 mine permit number M-1978-116, 87 mine permit number M-1979-094, HR SR-13A mine permit number M-1977-311, C-LP-21 mine permit number M-1977-305, CM-25 mine permit number M-1977-307, JD8 mine permit number M-1984-014, that we grant the continuance of
second temporary cessation hearing until February of 2020.
Do I hear a second?
Karen, second.
It's been moved and seconded. Any discussion? Hearing none, all those in favor? Yes, sir?
All right, go ahead. Sorry.
All those in favor signify by saying aye.
Aye.
All those opposed, same sign. Hearing none, the motion to allow the people to meet, allow our meeting to occur in February is accepted. Chuck, what else do we have here?
Public comment?
Yeah, I think that's it. John, just public comment and then, I'm sorry,
One comment?
Public comment. Do you have any public comment?
John, Ginny, question, Brandon has a comment.
Yeah, Chairman Sigmund, if it's okay, I'd just like to,
I have no comment. I think Jeff covered it quite well, so I will refrain on comment, further comment. Thank you.
Okay, thank you for tuning in.
Thanks.
Jenny, go ahead.
thank you, Mr. Chairman, members of the board. If I may, the Cotter hearing aside, not what I'm talking about, but when it comes to temporary cessation generally, it is hugely important. It's probably one of the most important rulemakings that will come before this board in a long time. And how we interpret the Court of Appeals decision and how we move forward based on the history of these sites and so forth. And I just wanted to just take this moment while folks are in the room and on the phone to thank everyone. We've met with Inform, with Jennifer and Jeff Parsons. We've met with Western Small Miners Association. We're going to meet with all of them again. And I just want to thank everybody. Jeff Parsons and his clients, Inform, San Juan Citizens Alliance, Mountain Alliance, and Earthworks, everybody in advance for giving us their valuable time to help us shape our thinking so that we can come to this board with the most thoughtful rule as a recommendation.
Okay, appreciate it. All right, any other business? Okay, well, then I thank everybody and we'll stand adjourned.